Okay. Send, well, you can send me a. Yep. Fred, what's going on? Oh, hi, how are you doing? Yeah, Manning, all right. Good to see you again.
Good evening, everyone, and welcome to the Kent County Board of Adjustment meeting for April 15th, 2021. We're going to call this meeting to order. When you're ready, will you call the roll, please?
Yes, ma'am. Mr. Cusick?
Here.
Mr. Jenkins?
Here.
Mr. Saunders?
Here.
Mr. Carlson?
Here.
Ms. Hudson?
Here.
Mr. Carter?
Here.
Ms. Denny?
Here.
Thank you, ma'am. That shows 7 present.
Thank you. Will you please introduce the staff?
Hi, I'm Jamie Fensky. I'll be the proceeding officer for tonight's meeting, and we also have Scott Blair, our other planner, on the line.
Okay, thank you. At this time, I'm going to ask everyone to rise and pledge allegiance to our flag. Do we have any additions to the agenda?
No, ma'am.
Okay. So when you're ready, will you introduce the public hearing?
Yes, ma'am. Sorry, I also forgot our legal counsel for tonight, Fred Townsend.
I didn't notice either, I apologize.
All right. So good evening, ladies and gentlemen. My name is Jamie Fensky, and I'll preside as the hearing officer for tonight's public hearing. This hearing is being conducted for the purpose of providing the citizens of the county an opportunity to present testimony on these applications before the Kent County Board of Adjustment. Everyone will have an opportunity to speak, and this will provide those who wish an opportunity to give their testimony. If there is a group of interested citizens in favor or opposed to any of the applications, they may wish to elect one spokesperson among them to present testimony to the board. There is an official recording of these proceedings being made. Therefore, we ask that only one person speak at a time and that they speak clearly. Furthermore, there shall be no cross-examination of witnesses permitted during the public hearing, but the board can ask the applicant questions after any opposition if necessary. As a courtesy to other participants in this hearing, a maximum of 5 minutes will be allotted to any person who wishes to provide testimony of any application. The chairperson of the Board of Adjustment has the discretion to allow additional time if deemed to be necessary. Statements presented at the meeting are to be made from the podium at the front of the room, and for the record, please give your name and address and allow our attorney to swear you in prior to providing testimony regarding your application. Copies of any written statements or exhibits used during the hearing should be presented for identification so that they may be included in the permanent record. The procedure on each application will be as follows. The legal notice will be read on each case prior to the received testimony. There will be a brief explanation of the application by the staff. The board will then receive testimony from those in favor of the application, followed by testimony of those opposed. Once those persons in favor and those in opposition have had an opportunity to speak, the hearing on that application will be declared closed. Decisions on these applications will be made by the board during the business meeting, which follows the public hearing this evening. However, you are not required to remain after the public hearing once your application has been heard and closed. During the business meeting, the board will consider all information of record. A common vote of 4 members of the board shall be required to make a decision on each application. If you do not wish to wait for the business meeting, later this evening, you may call the Kent County Planning Department tomorrow between 8 a.m. and 5 p.m. at 744-2471 or check the Kent County Planning website to learn of the board's ruling. All participants will receive written notification of the board's decision. This notice may not be mailed until after the next scheduled meeting, but if approved, you are welcome to apply for any necessary permits prior to receiving this by mail. Please keep this decision in your records for both you and all future property owners. The public notice of this evening's hearing was published on March 29th in the Delaware State News. In addition, all of the subject properties were posted with a sign prior to the hearing to further notify the public of the nature of the applications.
At this time, we're going to have a statement by counsel, the purpose of which is to help those who are going to give testimony this evening, what is acceptable as testimony before this particular body. Mr. Townsend.
Thank you, Ms. Denning. The test for the granting of area variances is set forth by the Delaware Supreme Court in the case known as Board of Adjustment versus Quick Check Realty. The test considers whether a literal interpretation of zoning regulations results in exceptional practical difficulties of ownership. To determine whether the exceptional practical difficulty test is met, this board must consider the following 4 factors. First, the nature of the zone where the property lies. Second, the character and uses of the immediate vicinity. Third, whether removal of the restriction on the applicant's property would seriously affect neighboring properties. And fourth, whether failure to remove the restrictions would create unnecessary hardship or exceptional practical difficulty for the owner in relation to the owner's efforts to make normal improvements to the property. This factor is met only when the difficulties alleged by the owner are practical rather than theoretical and exceptional rather than routine. The inability to improve one's business may qualify as an exceptional practical difficulty. And also, this consideration is where the board determines whether the applicant is seeking more relief than is minimally necessary to relieve the asserted difficulty. In general, the board is not permitted to consider factors other than the ones I listed. Therefore, those speaking both in support of and in opposition to applications are urged to present only information bearing directly on, first, the nature of the zoning district; second, the characteristics of the area; third, whether the requested variances would seriously affect neighboring properties; and fourth, whether the applicant is confronted with challenges rising to the level of exceptional practical difficulties. In particular, presenters are instructed to exclude from their testimony any discussion of personal disputes or acrimony between the applicant and neighboring property owners, as the board is not authorized to resolve such disputes. Ms. Denny, that constitutes my statement.
Thank you. Okay, so let's begin with the first case.
Yes, ma'am. All right, so first we have application A-21-06, Medding Family LLC. Sir, if you'd just like to wait just a moment, you could stand at the podium, but we'll go ahead and go over the application and then allow our attorney to swear you in. You're fine. The present zoning for the application is BG, which is general business. The proposed variance is from the 75-foot front setback from the right-of-way of an abutting major roadway and the required 40-foot rear setback to allow the enclosure of a legal non-conforming deck. The present use is a restaurant, and the proposed use is same with enclosed legal non-conforming deck. It's in the 4th Levy Court District for Mr. Buxton. It's located at the intersection of Bay Road and Kaydid Lane, south of Frederica. Here you'll see the existing legal non-conforming deck that they are asking to cover. It's within 50.7 feet from Bay Road and 34.58 feet from their rear property line. There's the existing deck that they are looking to cover. Looking south down the highway, north, straight on at the deck, again south, the area, and the high above area. Sir, if you want to go to the podium, you can state your name and address for the record and allow our attorney to swear you in.
My name is Robbie Medding. I reside at 661 Paris Kirby Road, Milford, Delaware.
Mr. Medding, do you solemnly swear the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Good evening, ladies and gentlemen. Thanks for having me tonight. I do have a confession. I forgot to bring the sign up. It's in my other truck, so I will run that up tomorrow. I was called and asked if I would bring that up tonight, and I'd leave it with the gentleman downstairs, and I'm guilty that I forgot. So that's the truth, the whole truth, nothing but the truth. So would you like me to go over some things, or would you like me to answer questions, or how would you like me to?
Actually, how it goes is you tell us what you're trying to do and why you're asking for relief from us.
Yes, ma'am. Well, the deck in the picture is something that we use in the summertime, and with the limited seating inside and different things outside, I've come up with the idea that if we close it in coming back into this next winter, that it'll be easier to have the capacity of seating that we need, since everything's been cut in half. And several months ago, we did an outside area that was temporary for the alcohol board, and we went ahead and expanded that permanently now, so we have another, of course, another bill, but we have another area that we can have more folks outside in a legal area. And this would be close to that area where the seats that are inside the building lost could be gained outside. The one setback would be 75 feet. We would be asking for 50 as it stated. And the other setback would be 40 to 34 and some change. That would be an adjacent to the property that my family owns south of the restaurant. Mr. Townsend went over a couple things that he wanted to cover. The nature of the zoning of the property where it lies is currently zoned BG, and it would stay BG. The character and the use of the immediate vicinity, the current and proposed use of the are inconsistent with the character and the uses of the immediate vicinity. Some of the other things that we've been working on with the Frederica South Master Plan is that all the surrounding areas plan to identify this property as the way it is also. I went through that. The removal of the restriction on the applicant's property would seriously affect the neighboring properties. Granted, the restriction variance would not seriously affect the neighbor's properties. The properties directly adjacent are owned by the same family. The two requests are not to extend the footprint of the deck, just to cover it. Does the failure remove? This request is a minimum reduction in the required setbacks while representing the least possible impact on the zoning code. This has also become a situation because the DelDOT has extended the area out front, which was different when we got the deck built, where we wouldn't have this problems if it was done enclosed then. Sorry about that. I'm not really good at all this.
That's okay, because what you're reading, we have read, because it's in our information packet. So unless I don't want to stop you from speaking if you have more to tell us, but.
If you're reading that, then you have everything that I have, and we're just trying to expand and keep growing in these changing times and trying to regroup. We've put new computer systems in to help get people outside. We've done different things to move the host from inside. So, it's a different business. It's a different world than it's been, and we're adapting. And this is one of the things that I think would help us succeed and staying afloat.
Okay. Anybody have questions or comments?
I just have one. Mr. Betting, so just to be clear, you're going to do away with that deck as it is and replace it with a permanent covered, enclosed, year-round structure, but in the same footprint?
Yes, sir. And I don't even know as at this point if we're going to take the deck up because it works. We might just have, depending, working with the county, what they'd like to see in engineers, whether it's an aluminum frame or a metal roof like the building is now, and we didn't put a lot of time and effort into that yet because we wanted to make sure that we were allowed to do it.
So essentially what you're saying is, it's your intention to enclose the deck,
Yes, ma'am.
and you'll file for the appropriate permits, and whatever the county says is necessary, that's where you're going.
Yes, ma'am.
Okay,
Absolutely.
okay. Anybody else? Okay, well, nobody has anything to say to you.
Thank you so much, guys.
Okay.
Is there anyone else in favor of this application? If there's anyone on the phone line, please press *3 to raise your hand and *6 to unmute your phone. Is there anyone in opposition of this application? Again, if there's anyone on the phone, please press *3 to raise your hand or *6 to unmute your phone. It's no one. Thank you. Seeing no one, we'll go ahead and move forward to the next application. Our next application is A21-07. We have Mr. Gambone in the room. This is for Andrew and Maria Gambone. The present zoning is RS1 for single-family residential. The proposed variance is a variance from the required 30% impervious surface maximum to allow the construction of a pool deck. The present use is residential, and the proposed is the same with the pool deck. It's in the 5th Levy Court District with Commissioner Sweeney, located on the north side of Chadwick Drive, east of Penwood Road, being lot 114 of the Penwood subdivision, south of Dover. You'll see here that Mr. and Mrs. Gambone's existing property area is 28,037 square feet with an existing impervious coverage of 31.3. They are proposing an additional 7.7%, being equivalent to 2,156 square feet, and they are asking for 39% impervious coverage in total. Here is an exhibit that the applicants have supplied showing the pool, the decking, and proposed trees that they are proposing to plant afterwards. The front of the home, down the road in the subdivision, the other way in the subdivision. Here is the backyard, and another view of the backyard. Down the side, aerial, and the farther out. Mr. Gambone, if you would like to state your name and address for the record and allow our attorney to swear you in.
Yes, my name is Andrew Gambone. I live at 17 Chadwick Drive, Dover, Delaware.
Sir, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Please proceed.
Good evening, everyone. Thank you for taking the time to hear our variance request tonight. By way of introduction, my wife and I moved to Delaware a little over 2 years ago with our 3 children and dog. Originally, we're from Philadelphia, and we relocated to Dover so I could take a position as an orthopedic surgeon at Bay Health. My wife's a physical therapist, and currently she's home raising our 3 sons. When we purchased our home, we had always considered the possibility of installing a pool in the backyard. Initially, though, we had safety concerns because of the relatively young ages of our children. So we started to enroll them in swimming lessons, and we soon found how much they loved to swim and how much they enjoyed being in our neighbors' pools. When the COVID pandemic hit, it became sort of an impetus for us to revisit our pool project idea. Going to recreational facilities and even visiting family and friends became somewhat more limited, especially me being at the hospital all the time and as a frontline healthcare worker. So my wife and I started to brainstorm for our backyard pool project. We wanted something that would be aesthetically pleasing and also functional for our family while being in line with the architecture of our home and adhering to the character of our community. Unfortunately, for all our initial planning, we were naive to the issue of the impervious coverage ordinance. While applying for the pool permit, we quickly learned that our property already exceeded the maximum impervious surface coverage by 1.3%. Now, we're the 3rd homeowners of the property, and besides some landscape additions that we've done, such as planting several trees and adding some landscape lighting, we have not added to the impervious coverage. As it stands, we would not be able to add or improve onto the property. And the way our home and property were developed, it would be very impractical and very difficult to alter the existing structures. We also learned during our research that our lot is approximately 0.64 to 0.65 acres, which is interesting because it's one of the smaller lots in Penwood. In fact, about 80% of the lots in Penwood are over 0.75 acres. And I think that's important because even a tenth of an acre is 4,356 square feet. Now, our project originally called for an increase of 7.7% to the existing impervious surface area. We chose travertine for the decking material for several reasons. For one, it's a natural stone that is quarried and eco-friendly. Any runoff through or along the stone would not contain any pollutants like would be the case in concrete or synthetic pavers. Travertine is also a porous stone. In addition, the application of the stone will be on 4 inches of gravel and 2 inches of sand, and studies have demonstrated that it can absorb as much as 68% of runoff in the first hour of rainfall. And the properties of travertine also lend it to staying cooler in temperature compared to other pavers or concrete. And from an aesthetic standpoint, we found that it blended well with the current architecture of our home. So when we learned of the 30% impervious surface issue, my wife and I wanted to help mitigate and be mindful of the stormwater management. Our project was already calling for the planting of 30 or more American pillar arborvitae trees along the back and side of the property. Now, these trees can reach 6 feet in diameter and about 25 feet in height. And studies have shown that on average, trees can absorb 10 gallons of water for every inch of trunk diameter. And the trees that we're planting will already be pretty mature at 8 to 9 feet in length. The other addition that we decided, we're also going to plan on installing 2 rain gardens to help absorb any runoff. Besides being aesthetically pleasing, the rain gardens will not only absorb the stormwater runoff, it will improve water quality and will further reduce any risk of flooding. And studies have shown that rain gardens can soak up to 30% of more water than typical grass. In addition to the implementation of stormwater management options, we looked to our project to see where we could further decrease impervious coverage without compromising practicality and functionality of the space. Now, we were able to remove some of the decking to decrease the amount of impervious surface needed to 6.9%. We also looked to decreasing the pool size, but we felt that this would affect both the recreational and exercise functionality of it. In addition, as you saw in the pictures, because of the way the house is constructed with the secondary garage and the den, decreasing the size of the pool would not technically decrease the decking requirements. And now I would like to touch briefly on some of the Department of Planning Services concerns in their recommendation report. As you can see from the aerial view, it's in one of the handouts, there are many pools in the surrounding area. Therefore, we're not asking for any more or less, but asking to have the same opportunity to make the improvements that have been allowed of our neighbors. The lack of variances on record may be more due to historical reasons, and although exact calculations are not available, it would appear that the properties with pools, decking, and other impervious structures may exceed the 30% lot coverage under the current zoning ordinance. In addition to our lot size being smaller on average for the neighborhood, we did not have a say in the construction of the house or the development of the property. Therefore, both of these conditions were not created by us. Addressing the amount of decking we are requesting, the requested coverage variance only seeks what is necessary to build an aesthetically pleasing and functional space. We purposely decreased the decking requested and implemented stormwater management with the planting of 30 new trees and the rain gardens. We were also particularly mindful in using an eco-friendly and a porous material such as travertine stone. Lastly, there have been no reported issues of flooding on the property, and in one of the other handouts, nor does FEMA consider it to be within a floodplain. With these factors taken into consideration, we do not feel that we will cause undue stress to the stormwater management in our area. In fact, I think we're looking to improve the stormwater management with natural rain absorption from trees, rain gardens, and the porous stone. Our neighbors who are in the immediate vicinity have all submitted letters of support. They're aware of the variance we are seeking, and they have been given our plans for review. In addition, the Penwood Homeowners Association has also approved our project from an HOA standpoint. So at this time, I don't know if anyone, no one came. At this time, I would like to petition the board to approve our request of an additional 6.9% to the current impervious coverage. So we did drop it a little bit. Thank you.
Okay. Anybody have any questions? Okay, go ahead.
I do. When you're talking about your gardens, your rain gardens, now, are they that water gonna run off to somewhere else? Like a storm drain or anything?
Well, we're going to divert the storm drains to the trees and the rain gardens, and the decking will be sloped so it collects. The rain gardens will be at each corner.
Anybody else? Okay, I just as a matter of housekeeping, I am a retired from administration to an orthopedic practice here in Dover, and I certainly don't know which one, nor do I need to know which one you're with. However, that said, I just want to state now, I don't see a need for me to recuse myself from this, but I just for the record, okay? Okay, that's it.
Thank you very much.
Ms. Denny,
Yes,
may I ask a question of staff?
sure.
Is the rain garden part of the application? And is this has the staff evaluated that aspect of it?
We did not know about the rain garden. I don't know what it will be constructed of, so I don't know if it will count towards impervious coverage or not.
So the question then becomes, does this group, if this group wished to move forward with a motion to grant, would it be made conditional upon installation of a rain garden or two? And if so, what would the dimensions be, that kind of thing? So we may want to explore that
Okay.
with the applicant.
Okay, well, if you don't mind, can you give us a little more information on the rain gardens? Thank you, Mr. Townsend.
Sure. Well, rain gardens, I mean, they're basically, I guess, indentations or holes in the ground where you plant plants or grass that are deep-rooted. The way we cut the deck, we're going to probably make the rain garden 6 by 6. The one may be larger, the one on the east side of the property. And we weren't originally going to do that, and that's why it wasn't in the application. But when we were researching all this, we thought it was a good idea. Now, we thought with the 30 trees, that would be a good idea too, but that was in the application. We just thought maybe it was an extra step to go, and it would probably look nice as well.
And as you are aware, obviously, there's the St. John's that runs somewhat behind, not Chadwick, but so I've never been aware myself of any flooding over there, but obviously, when you start having draining type issues, it can make really poor neighbors, but it sounds like you're doing everything you can to avoid that. Anybody else now with the new information?
Just one last question.
Yes.
Did you give any consideration in your decking to a material or deck that had, where water would go through, such as
The permeable pavers.
Trex or whatever?
Correct, yes, we did. A couple of things on that. We did research them, we did look at them. One, they weren't the most aesthetically pleasing things. Two, they can actually, over time, without proper maintenance, get clogged. So the permeable pavers become impermeable. So we did consider it, but we felt with the travertine, which was a porous stone, that it would equalize out to a certain extent.
Anybody else?
Yeah, I see a catch basin in the yard. Does that exist in there?
Yes, there is a catch basin. We will not be doing anything with
Utilizing
it.
that?
It's just going to stay there, yeah.
Anybody else? Thank you, Doctor.
Thank you very much.
Is there anyone that would like to speak in favor of this application? If you are on the phone, please press *3 to raise your hand or *6 to unmute. Is there anyone that would like to speak in opposition of this application? If you are on the phone, please press star 3 to raise your hand or star 6 to unmute. Seeing no one, we will move to the next application. We have application A-21-08, Willow Cap LLC. Is there someone here to speak on this behalf? Thank you. All right, so we have the applicant and owner as Willow Cap LLC. Present zoning district is AC, Agricultural Conservation. The proposed variance is from the 25-foot aggregate side setback to allow the construction of a single-family dwelling. The present use is vacant. Proposed use will be a single-family dwelling. It's in the First Levy Court District for Miss Maston. It's located on the east side of Azalea Drive, north of Red Maple Road, being lot 341 of the Willowwood subdivision, south of Smyrna. The applicant is requesting the variance from the 25-foot aggregate side setback. They are asking for a total aggregate of 22.4 feet and asking for a variance of 2.6 feet. Here's looking right on at the site. Down the road at the existing homes. At the one side of the property line and the other. Down the other side of the road. And the aerial. Sir, if you would like to state your name, address, and allow our attorney to swear you in.
Sure, it's Mike Ryman, 309 South Governors Avenue, Dover, Delaware.
Mr. Ryan, do you affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Is it okay to take this off, or I keep it on the whole time?
You really shouldn't.
Everywhere is a little different, so it's okay.
Yeah.
So as I said, my name is Mike Ryman. We're the civil engineers for the project. We're here tonight to request a variance for the subject parcel. I'm here representing the property owner, Willow Cap LLC. The request is for lot 341 within the Willowwood community to construct a new home, a single-family residential home. This one's a little bit interesting in that as we go through the criteria here, and specifically the nature of the zone, if you could go back to the zoning map, I will start there. So Willowwood is comprised of actually AC and RS1 zoning. So all of the zoning in green, that portion of the community is zoned AC, and the portion in yellow is RS1. So a little bit unusual in that the community itself actually has two different zoning districts within the same subdivision throughout. And that's important because in the RS1 zoning district, the minimum setbacks are 10 feet on each side of the lot. Within the AC zoning district, it's also a minimum of 10 feet, but an aggregate of 25. So essentially 10 and 15, or 12 and a half and 12 and a half. So, you know, as it relates to the nature of the zoning district, our request to be a minimum, and I believe on the plan that we sent you, is 11.2 and 11.2. We do believe that we're consistent in the subdivision as we exceed the minimum 10 feet, which is consistent with a large portion of the community that is zoned RS1 with a minimum of 10 feet. As it relates to the character of the uses in the immediate vicinity, it's no change in character, single-family home. In fact, this particular home, which is called the Cambridge model, has been built 15 different times throughout the community. So will certainly be in keeping with the character of the development. This home has been built in the community throughout. And again, you know, with the setbacks being 11.2 on each side for a total of 22.4, it would be very consistent with a large portion of the community that the setbacks are only 10 feet on each side or 20 feet in total. Whether the removal of the restriction on the applicant's property would seriously affect the neighboring properties. We don't think so. And if you go back to the graphic that shows the setbacks. Yeah, so what's not shown on here, but I think it should be in your packet on the plan that we submitted. It looks like it got cut off when it was clipped for the PowerPoint, but if you look in the plan that we attached, you'll see that there already are 2 existing dwellings constructed on either side of the lot. So they are there and they are in place. And if all of these houses were to be at the building restriction line, you could have houses as close as 20 feet on one side and 25 on the other. So you could have 10 and 10 on one side, and you could have 10 and 15 on the other. And so houses would be between 20 and 25 feet. We have the benefit of actually having the existing homes constructed on either side of us, and on the left side of the project or the house, we're 22.8 feet, and on the right side, we're actually 29.1 feet. So we don't believe it would be an adverse impact. It would be very consistent with other portions of the development. In fact, the lot 2 are, I guess it would be left there between lots 342 and 343, are only 26.3 feet apart. So we're at 29.1. So we don't think there would be a negative impact there. And then the last criteria, whether the failure to remove the restriction would create an unnecessary hardship or exceptional practical difficulty. So this home has been under contract for about 4 months. The homeowners are renting. There are pretty significant lead times on materials. They've secured materials already. If we were to have to abandon this model, this is the home that this family chose and wants to build on this lot and it's moved forward with. This would be a pretty significant impact to have to start over essentially from scratch, and would delay delivery of their home, and they would have to modify their plans. So we do think this would have a pretty significant hardship to the property owner. So again, our request is not to go below the minimum of the 10 feet, but to reduce the aggregate from 25 by 2.6 feet. And we do believe that we meet the 4 criteria, and we respectfully request your approval. And if you have any questions, I'd be happy to answer them.
Go ahead.
Mike, I assume that since builders have changed 2 or 3 times in this project, I assume the models of houses have changed as well.
Yeah, I think that would be fair to say. Yep.
I need to go on record that I'll be recusing myself from this application as I'm employed by the same company as who's representing this application.
Thank you.
Anybody else have comments or questions?
I got the question. You said that 15 houses have been built of that model. Were they built in the AC or the RC1?
No, they're in a combination of both zoning districts. I don't have those exact lots offhand, but they're throughout the community.
And so none of those houses obviously required variance.
No, this lot's just a little bit narrower than some of the other lots in the zoning district.
Okay. Anybody else? Thank you.
Thank you.
I had a quick question for you really fast. Have the homeowners already purchased the property and said house, or is it just under contract waiting for the variance?
Under contract.
Okay.
Under contract. Good.
Is there anyone else that would like to speak in favor of this application? If you are on the phone line, please press *3 to raise your hand or *6 to unmute your phone. Is there anyone here that would like to speak in opposition of this request? If you are on the phone, please press *3 or *6 to unmute your phone. Ms. Denny, that is our last application for tonight.
Well, thank you so much. So at this point, members of the board, do you want to just continue on to the public hearing, or do we need a break? Just roll on, everybody's agreement? Okay, so at this point, the public hearing is closed, and we are now calling to order the business meeting. Just because, please call the roll.
Yes, ma'am. Mr. Cusick?
Here.
Mr. Jenkins?
Here.
Mr. Saunders?
Here.
Mr. Carlson?
Here.
Ms. Hudson?
Here.
Mr. Carter?
Here,
Ms. Denny?
Here.
Thank you, ma'am. That shows 7 present.
Thank you. So we are now calling to order the business meeting. First order of business is the minutes from the March 18th, 2021 business meeting. So I need a motion and a second.
I make a motion, we approve the minutes of the March 18th meeting as presented.
I second.
Okay, we have a motion and a second. All in favor?
Aye.
Aye. Any nays?
Just one abstaining. I was absent from that.
Okay, one abstain. Okay, so therefore the minutes are approved. Notice of decisions, and they are A2104 and A2105.
Carlson, I make a motion to approve the decisions A2104, A2105 from the March 29th meeting.
Second.
Sorry, that was the March 18th meeting.
March 18th, yep.
Yep, that's what I meant, March 18th.
Okay, so we have a motion and a second. All in favor?
Aye.
Any nays?
Just one abstaining.
One abstaining, okay. Having only one abstain, we therefore have the appropriate amount of positive votes. Notice of decisions are hereby approved. It appears as though we have no old business. And here we are at new business. And I think one of the applicants has left. So we'll just start with the people who remain.
Yes, ma'am. So we'll start with application A-21-07, Mr. and Mrs. Gambone. They are requesting the variance from the required 30% impervious surface maximum to allow the construction of a pool deck, and they are asking for a variance to 39% impervious coverage.
Okay, anybody have any comments or discussion?
I'll just make the comment that we have a paver patio at our house, and I've always been amazed at how much water drains through it.
Okay, thank you. Anybody else? Okay, well, I am going to just say that based on, I know we all got this folder tonight, but I had just a few minutes to peruse it, but I actually was pretty impressed with, myself about the amount of drainage with this rain garden situation. So that said, I'm looking for a motion, unless there's somebody else has something to add.
Carlson, I'll make a motion to approve A2107 based on the fact that the smaller lot size than normal in the community will not really allow for much less decking, and that the owner is making several improvements to address the drainage in the decking, rain gardens, plantings of trees. No neighbors have objected, and the homeowners association seems to have given its graces to the project. I think that with all these improvements, it will not create a problem to any neighboring properties.
Second.
Okay, we have a motion and a second, and when you're ready, please call the roll.
Ms. Denny, one question.
Okay?
So is the motion contingent upon installation of the rain gardens?
Well,
Okay, I can
So
add to my motion that given the testimony of the owner that he's going to be placing rain gardens in place as part of the plan, that it would be conditional upon those being placed on the property.
as is demonstrated by the plan that was sent to us tonight.
Correct.
Okay.
And secondly, is this Blue Haven Pools sketch indicates that there's a patio to be removed? Is that right? No. Oh, okay, all right.
Okay, so we have restated the motion to include the drainage, the rain garden being applied as is described in the pamphlet we were given this evening. And so does whoever seconded that want to?
Second.
Okay. So now call the roll.
Yes, ma'am. Mr. Jenkins?
I vote yes in support of application A21-07 based upon the reasons stated in the motion and the testimony of the applicant.
Thank you. Mr. Carter?
I'll vote yes on the motion based on the testimony tonight and the discussion of the board.
Ms. Hudson?
I vote to approve A-2107 based off the nature of the zone does not change, the character and use stays the same, removal of the restriction doesn't affect the neighboring properties, and the homeowners are willing to work with the board and to install rain gardens to deter flooding in the neighborhoods.
Thank you. Mr. Saunders?
I vote yes to approve A-21-07. Based upon testimony, no opposition, it won't change the character of use, and a lot of due diligence to be conservative.
Thank you. Mr. Cusick?
I vote yes per the motion to approve application A21-07. Per the testimony, the applicant has done his due diligence with the material selections that he's using, and then also the additional landscaping that he's planning on doing. The approval of the surrounding neighbors, obviously it won't impact the neighboring properties at all. And the hardship is there to stay competitive within the housing market in that area.
Thank you. Mr. Carlson?
I vote yes to approve based on my motion this evening.
Thank you. And Ms. Denny?
I'm going to vote yes. I think I can appreciate this homeowner has gone above and beyond in order to alter and make the best of this situation. And as stated during the testimony and confirmed by the planner present, the rain tree garden was not part of the original application, and therefore the planners who recommended denial did not have the opportunity to see what we have seen with this packet. So therefore, I vote yes.
Thank you, ma'am. That is 7 yeas and 0 nays.
Having received unanimous positive votes, application A27 is hereby approved. So now tell me what practice you're with. Oh.
Yeah, they started expanding their orthopedic. So
Wonderful. So are you working with Issue and Trinity? Yeah. Okay. Well, send them my best.
Thank you.
Okay, we have the next one is, okay, go ahead.
Next application is A21-08, which is Willow Cap LLC. They're requesting variance from the 25-foot aggregate side setback to allow the construction of a single-family dwelling. They are asking for the aggregate to be 22.4, which would be a variance request of 2.6 feet.
Just to go on record, I'll be recusing myself on this application.
Thank you, sir.
Okay. Comments or thoughts or a motion?
I'll make a motion to approve application A2108. I'm very familiar with this development. I have a sister-in-law that lives there. I don't see where this is going to have any effect on the neighbors or the neighborhood. So based on the testimony tonight, and as I said, the builders have changed in this development at least 2 times, maybe 3, so the housing models have changed as well. So I move to approve it.
Okay, we have a motion. We're in need of a second.
Crossan, I'll second the motion.
Okay, we have a motion and a second. If there's no discussion, call the roll.
Thank you, ma'am. Mr. Jenkins?
I vote yes in support of application A21-08 because the variance of 2.6 feet and my experience in that particular subdivision as a electrical contractor, I don't see the impact that 2.6 feet would have on the environment of the community on either side, the neighbors on either side of that parcel.
Thank you. Ms. Hudson?
For A-21-08, I vote no. I vote to deny based off the staff recommendation. I believe that removing the restriction would impact the neighboring properties. And I don't see unnecessary hardship where the foot plan could be just moved over or expanded to fit the current setbacks.
Thank you. Mr. Saunders?
I vote yes to approve A-21-08 based upon your testimony, and I don't believe there would be any adverse effects to the property, neighboring properties.
Thank you. Mr. Carlson?
I'll vote to approve A-21-08 based on the fact that 2.6 feet shouldn't have an effect on the neighboring properties, and it wouldn't change the vicinity, immediate vicinity, the character of the immediate vicinity. And based on the testimony given this evening on the nature of the development and the 2 different zonings, and many of the lots already have, although they might have been within the proper setbacks, or a lot of them are all offset to different dimensions, so it should not really make a difference.
Thank you. Mr. Carter?
I vote yes to approve A2108 based on my motion and the testimony tonight.
Thank you. Ms. Denny?
Okay, these tend to be difficult for me, and so I'm going to vote yes, and I feel as though there's a couple of differences here. One is that based on testimony, it's not making a huge difference in the distance between the houses, which I feel is important. But I need to be very clear that this is not setting a precedent, and I would hope that these builders would not come back to us with another situation like this. When you have that many empty lots, you shouldn't be showing lots houses don't fit on. And you know, we see this from time to time. You know, it's like, and I'm not opening Pandora's box here. This is not a precedent, and I don't want to see the same people back with the same issue, in my opinion. Thank you.
Thank you, ma'am. That is 5 yeas, 1 nay, and 1 recusing himself.
Okay, having received the appropriate amount of positive votes, A2108 is hereby approved.
Thank you.
So last but not least is Medding.
Yes, ma'am. It's application A-21-06. They are requesting a variance from the 75-foot front setback from the right-of-way of an abutting major roadway and the required 40-foot rear setback to allow the enclosure of a legal non-conforming deck. They're asking for the front setback to be 50.7 feet and the rear 34.58 feet.
Okay, any thoughts or discussion or a motion?
I'll make a motion, Eric Crossan. I'll make a motion to approve A21-06 from Medding Family LLC based on the staff recommendations for approval and the testimony given by the owner this evening. The existing area footprint of the deck will not be changed, simply enclosed. I frequent that property once in a while, and it seems like nothing's changing other than the fact that they're putting up walls and a roof over it.
Second.
Okay, we have a motion and a second. Call the roll.
Yes, ma'am. Ms. Hudson?
For A-21-06, I vote to approve based off staff recommendation. The nature of the zone does not change, and the character and use of the immediate facility does not change as well.
Thank you. Mr. Saunders?
I vote yes to approve A-21-06 based on staff recommendations.
Thank you. Mr. Jenkins?
I vote yes in favor of application A21-06 based on the fact that failure to provide this variance, I think, could pose economic hardship on the applicant in a very difficult climate that we're in at this present time.
Thank you. Mr. Cusick?
I vote yes per the motion to approve application A21-06 per staff recommendation and per the applicant's testimony to stay competitive within the times that we're in right now.
Thank you. Mr. Carter?
I vote yes, based on the staff recommendation and testimony given tonight.
Thank you. Mr. Carlson?
I vote yes to approve based on my motion this evening.
Thank you. And Ms. Denny?
I'm going to vote yes for both requests. Again, based on the staff recommendation, and although I don't think we should risk setting a precedence that if you come here and say you have a COVID issue, that it can be an excuse as opposed to a reason. But again, this is what makes this unique is this deck already exists. They want to enclose it so that they can meet the requirements. And so this is here, and they're just putting a roof over it.
Thank you, ma'am. That's 7 yeas and 0 nays.
So having received unanimous positive votes, application A2106 is hereby approved. So that's it. We're looking for a motion to adjourn.
I make a motion, we adjourn.
Second.
All in favor?
Aye.
Meeting adjourned. Everybody, it looks like next month, bring your pajamas and a nightcap.